Hey there, welcome to Talking Texas Politics with Calvin. We are here at the historic Cooke County Courthouse again, here in Gainesville, Texas, and today I'm here with Ed Zielinski. Ed is the county attorney here in Cooke County, so that's kind of a rarity in the state of Texas, from what I understand. So, Ed, why don't you introduce yourself to
Okay,
the folks and then tell us a little bit about the county attorney role and what exactly you do?
very good. Well, I got into the county attorney business by running for office in 2012. I was asked by local law enforcement and some folks because they felt like there had been sort of a malaise in the county attorney's office. Things were not moving as quickly as possible, and there were some questions about what kind of support the county was getting. Um, the county attorney's office in Texas is kind of unique in that were a carryover from the Spanish tradition and the Mexican tradition of prosecutors located to a particular province or a county. Uh, Civil War happens. Post Civil War, there's Reconstruction. There were district courts, there were district attorneys, but counties wanted to have their own representation. So what they did is in the 1866 Constitution, the commissioners court at that time called the county board was allowed to appoint a person to be the county attorney. The job was to assist the county in giving them legal advice, to prosecute when the district attorney wasn't available, and to allow sort of a local control over how the operations of county government ran. That constitution was then done again in 1876 post Reconstruction. It became more and more of a position that required a lot more activity in terms of prosecuting in the courtrooms. By 1876, it was an elected term, and it was for 2 years. And by 1954, it was back to a 4-year term to an elected office. So I've been elected since 2012. I took office January 2013 and have been here ever since. The role of the county attorney's office now is much different than it was at its onset. We're responsible for prosecuting those cases involving misdemeanors for adults and prosecuting everything that involves juveniles. We also have to provide advice to the departments of county government, give them an idea of what they can and cannot do. Oftentimes, as any attorney will tell you, your client sometimes will want a particular result, and sometimes it just doesn't fit the law. And so you're not always the bearer of glad tidings to the different departments, but you've got to tell them what the law is. You've got to apply the facts to the law, and if it doesn't fit, it doesn't fit. As far as prosecutions are concerned, the bulk of our prosecutions involve people who probably will not offend again. I would say probably 80 to 85% of the people that we deal with will commit a crime one time and get on the straight and narrow and probably won't be a problem again. The remainder tend to recommit crimes and they become recidivists. They will commit more crimes down the road, and oftentimes they'll lead into the felony ballpark. So, what our job here is to get people back into the lane of traffic, having them operate within the parameters of society and not violate the law.
Okay. So, what would you say you spent, I guess, most of your time on?
Well, 60% of my time, I was looking at this the other day when you asked me to do this. Probably 60% of my time is involved in supervising prosecution. I have an assistant county attorney who does nothing but prosecution. So, what I do is the process in our office is law enforcement brings a case to us. That case is reviewed by my investigators. The investigators then make a recommendation based on the case, determining whether or not we have all the evidence, whether or not we can make that case work. I then review that case before it's filed as an information or complaint. I sign every information and complaint. So it's my responsibility when I charge a person to know that I can prove the case. Now, what happens from that point forward is once they are served, once they're in court, then it becomes our purpose to find out what fits that particular crime. So a DWI in and of itself is an offense, but there are different types of offenders for DWI. You might have a person who is young, made a bare minimum mistake, had an intoxication level, but did not have any kind of an accident or any kind of injury to other people. was involved in something that barely went over the minimum for DWI, which is a 0.08 blood alcohol level. Then there's the person who comes out of their knee walking drunk and they're over a 0.3. Different kinds of cases. Range of punishment then determines how far we're going to go with that case and whether they're going to be looking at 6 months in jail or a year in jail.
So you mentioned that there's a limited number of county attorneys in Texas, and I think when people think of like they look at district attorneys.
Right.
So what's the difference between a
Well,
district attorney and a county?
In some counties, you have what's called a criminal district attorney. And that office is a combination of the county attorney's activities and the district attorney's activities. For example, both Denton County and Grayson County operate that way. Smaller counties, Montague, Clay, Archer, Cooke, they have a county attorney. Wise County, same thing. They've got a district attorney and a county attorney. And what's confusing to the general public is they think prosecutor, they think of TV programs, and they're always talking about the DA. Mm-hmm. Well, the reason the county attorney is in place is because most of the criminal activity by volume is going to be misdemeanor activity. And so what our office does is we deal with that high volume of misdemeanor activity. As I started to say, we go through this process, we get them charged, then we review the cases, determine how that should be handled. And I would say that probably over 95% of our cases end up in pleas because people realize that we got the evidence, we got the facts, the law's on our side, they don't want to go to trial. And the ones that go to trial, we have a high success rate on. I think statistically, the Department of Justice will tell you that of the cases that go to trial, 80% are convictions. So across the United States.
Okay. Now, you said that it was it's an elected position.
Correct.
For a 4-year term, and you've been here since 2012.
Mm-hmm. Well, so, 2013 is my first day.
Okay. Yeah. Okay. 2013. So in that 12 years, 13 years, what would you say was your biggest accomplishment?
Well, the thing I'm proudest of is our ability to move cases at a higher velocity. There's a really important factor. When a person is charged with a crime, if they're of the belief that it'll just stay on the books and hang out there for a while and they'll never be convicted, it's not a real deterrent to criminal activity. Mm-hmm. So what we try to do is, for example, in a drug case, if you're the district attorney's office, person's charged with possession of drugs, you got to get those drugs tested. There's a delay in the laboratory work, so there takes more time to get that case to trial. On the cases I've got, the information and complaint is designed to get forward quickly. So if I have a DWI case, probably within 45 days of the date of arrest, we will have a charge filed against them. And then at that point, the county court of law moves that case along for several hearings. The first hearing is an arraignment where they come in, they plead guilty or not guilty. We talk to them about whether or not we want to make a plea offer to them or not. Then the next step is a pretrial hearing. At that pretrial hearing, if there are discovery issues, if they're looking for evidence, if they have a problem with the suppression idea, all that gets addressed. Then we go to a trial announcement. And at trial announcement, it's fish or cut bait. Either plead the case or you'll try it. Most people, like I said, are interested in pleading their cases. And I try to be really reasonable, and my assistant tries to be very reasonable in the way that we handle those pleas. If a person is employed and they've got a family that they're raising, there's really not any great benefit to putting that person in jail unless they've done something real heinous. The other thing we have to think about is every time we put somebody in jail, it costs the county money because they're not paying for their room and board there. And invariably, we are. So we have, 250 some odd beds available. If we took the 800 cases we get a year and put everybody in jail, you can see the backlog would be a little difficult.
So what would you like to accomplish moving forward?
Well, we started a program of pretrial intervention, and that's commonly done across the state. What it's designed to do is you look at that offense and you look at the offender. And if that offender is in a position where they don't have a prior or their circumstances are such that they might have a professional license problem, or they are in a position where, as I said, raising a family, taking care of things, and they make a mistake. Getting marked with a misdemeanor offense conviction can impair their ability to be employed somewhere down the road. For example, on a DWI. If you've got a marginal DWI, no damage from an accident, no one was hurt in the process, we put them on pretrial intervention. It's not a slap on the wrist. We make that a longer period of supervision than they normally get with supervision through the community supervision office. We have them attending particular classes. I've got an investigator that monitors them individually so that we're constantly on top of them to make sure they've done the things they're supposed to do. And our success rate with those is really high. It's over 90%. So that person completes the program effectively. They don't have a conviction on their record. But for my records, I know they've had pretrial intervention. So if they come to bat a second time, we don't play that way.
Okay. So now, a few years ago, it seemed like there was some discussion about actually getting rid of the county attorney
Well,
position.
what we're going to try to do is combine the county and the district attorney's office.
Okay.
And we looked at that from a pure economic standpoint, that as the volume of cases increases, which it will, it always does, as those cases are addressed, there is an efficiency in handling all the cases through one particular funnel. So, for example, you might have a person who's pulled over along the highway for a DWI. And within the context of that arrest, they find some controlled substance. Now you have a misdemeanor case over here for the DWI, and you have a felony case over here. And oftentimes the felony case takes longer to progress, so this DWI case is going to be laying behind that felony case. If you're trying them together, what you might be able to do is try the DWI case, incorporate the felony with it, and make a deal for both. But right now they deal with two different offices. Now the district attorney and I have a good working relationship, and oftentimes we can work those out. But it's a case-by-case operation. If you had a single funnel and a single arbiter of what to do with those cases, it would move that much quicker. So we probably would not get rid of lawyers. What we would do is make them more effective. So for example, we have 2 lawyers down here. They have 3 upstairs. Well, now they're going to have 2 because one of them is going to be a federal prosecutor. But you can then take that legal team and apply them to the cases that need trials, and then rotate them through different processes, like handling the misdemeanor cases, handling the juvenile cases, handling the stuff in justice of the peace court, which is another one of our responsibilities. All these traffic offenses that come through, they want a trial, we try them. Now, a lot of people think that if I ask for a trial in JP court, the case will go away. Well, that's not what happens. We try those cases. And we've had several people that thought that, that the juries would certainly see that their opinion of their speed was better than the trooper's opinion. And pretty much they fail. Those troopers are using radar equipment. They're professional. They're trained. Juries look at them and say they know what they're doing. And the driver is basically got a sort of a bias towards their case.
So, so moving forward, and you get to see things from a lot different perspective than most of the folks in Cooke County do. What do you think is our biggest obstacle, risk moving forward as growth comes? What do you see?
Well, we got a couple things going on. Right now, our interstate highway has in excess of 100,000 cars moving through it. Between I-35 and US 82, 100,000 cars moving through the county, probably much more than that. We're going to have a 6-lane Interstate 35, and Highway 82 is already pretty much packed up because people are trying to get around construction all the time. As that volume increases, statistics tell us, once again, Department of Justice statistics over the last 20 years says that you can pretty much account that out of any given population, 3% of the people are committing crimes. So 100,000 cars, that's 3,000 cars that are doing something wrong. Do we have the facility to handle 3,000 crimes? Well, you have to have officers in place to suspect those people, have probable cause to stop, arrest, and proceed. But our volume is not going to get smaller. We're not going to reduce the size of what comes through these courts. So we have to address that. The second thing we have to address, particularly in juvenile cases, I'm seeing a higher volume of juvenile cases and much more violent cases. Juvenile cases, when I first took office, most of them were criminal mischief, theft, things of that character. Now I'm seeing violent crime. I'm seeing people pulling knives, having guns,
Oh, wow.
drugs, vapes, all kinds of stuff. So we now have to think about what we're doing with that juvenile offender. And the state, because of the way that things are structured, we don't have beds equivalent to the number of offenders that have to go into facilities like state schools. So what we have to do is the juvenile justice system is trying to address that. And we work with our juvenile probation office to address that. We're trying to make sure that once we have a juvenile offender, they're handled in a way that prevents them from reoffending. So we work hard at rehabilitative programs. We try to get them in placement if they need placement. But the last place we want to try to put them is into a university of crime, which is a confinement facility.
Wow, those are things that a lot of people don't think about. So, with us being so close to the Oklahoma border, they have medical marijuana legalized. Right. They also have legalized gambling. Have you seen any impacts from that type of activity?
Oh, yeah. We get people, young students traveling through the state of Oklahoma buying vape cartridges with THC in them. The consequence is that THC vape cartridge is a second-degree felony. They go to the apothecary up there. They get themselves a container of marijuana. They say, well, I got this card that says it's medical marijuana. I can use it. Well, not here. Once you cross that Red River, life is different. And we have a lot of people that come in and they really don't understand the difference because they think that if it's legal in Oklahoma, it must be legal in Texas. And the general public doesn't look at it as though there's a great distinction between the two states. Well, there is. The other problem that we face is the general society's view of possession of marijuana is much different today than it was a couple decades ago. Now, people don't think that's as serious an event. As long as it's on the books, we have to prosecute it. One of the problems that we face is, one of the issues that all prosecutors are dealing with right now, is the facility of state laboratories to test marijuana. Because as you recall, several years ago, they started talking about what the concentration of THC has to be in the marijuana to make it qualify as illegal marijuana versus hemp. Defense lawyers are real savvy to that. So what will happen is if you have a marijuana case and there's a question about whether or not you can prove the concentration of THC in that marijuana, we have to send it off to a laboratory. I alluded to earlier that the district attorney's office has a lot of times a delay in prosecuting drug cases simply because of the time involved in getting the drug results. Well, if they're looking at measuring cocaine versus measuring marijuana, what do you think the priority in that laboratory is?
Right.
So we end up on a back burner. We have a 2-year statute of limitations on these misdemeanor cases. So what I rely upon is the police officers doing field testing, recognizing the marijuana, recognizing the odor, sometimes the admission of the people there. The nice thing about those containers coming out of Oklahoma is they say exactly what they are. So it's kind of hard for them to say, I thought I bought a can of hemp. So we have some advantages there. And most people look at it as a practical matter that once they realize marijuana is illegal in the state, they will enter into a plea bargain for the purpose of getting through that process. Because if it's a lay down, there's no point in trying the case.
So, the legislatures in session here in Texas, and they just banned THC. What's the if the law was on the books? Was there explain what that means when they say they ban THC?
Well, what they're saying is concentrations of THC in a product are not going to be allowed. We're going to consider that illegal. Okay. What they'll do is they'll come up with another imagination of the health and safety code and identify what that violation is, because that's where marijuana is right now in the health and safety code. And so invariably what we will see is the same kind of thing we're dealing with now. There are going to be people out there that say, well, this is this is not marijuana. This is just a medicine with THC in it. Well, depending on what they write that law as, we're going to look at those as violations. And there's a lot of things that people are taking now that are over the counter, actually over the internet, that they're purchasing for pain resolution or whatever. And if they are tested, they will have a THC level in their blood. And one of the problems with marijuana in terms of intoxication and impairment is marijuana is fat soluble. It's not water soluble. Alcohol is water soluble. We've got a lot of testing about alcohol and concentrations and impairment. But if you've got a person who regularly uses marijuana, it will stay in their system for a long time. They've done some tests on people in jail and in prisons where they have isolated them from the availability of marijuana, and they've been there 90, 120 days, and testing their blood, they will still find a high THC level because it doesn't dissolve so quickly.
Wow. That's interesting. So the legislature is in session. So everybody's kind of got to hold on to their wallets and hope everything works out okay. Is there anything that has happened in the legislative session that would impact your role?
Well, every time the legislature meets, they change a lot of penal laws. They are spread out throughout the statutes of the state of Texas. Like I was saying, the Health and Safety Code has criminal violations in it. The Penal Code has criminal violations in it. There are a lot of questions that always come about when the legislature finally puts the final kibosh on what they're going to do for a session. We get an update of all the things that are different. The biggest thing that we concern ourselves with is what happens with range of punishment or characterization of crime. Because right now we have the A, B, and C misdemeanors. C's are traffic tickets, things like that. The A and B misdemeanors involve confinement. B's are up to 6 months. A's are a year. But then we have the state jail felony, where a person can go to a state jail facility, not the penitentiary, but under the state jail facility, you don't get parole. Then you've got the first, second, and third degree felonies, and you've got the capital felonies. All those things have adjustments to them. So that's the stuff we look at carefully, because we have to operate based on the crime that existed and the punishment that existed at the time of the event. That's what we look at. So something that is a new law in September of 25 is not going to be the same as something being prosecuted for an event that was in 24. So we have to stay on top of that.
So there's been one of the priorities for both the governor and lieutenant governor was bail reform. So what's the deal with bail reform?
Well, the Constitution says that bail cannot be used as a punishment. So if a person is accused of a crime and confined, you as a judge, as a magistrate, are not supposed to set a bond at a level that is punitive, but it's supposed to be set to protect the public from future harm or to assure the appearance of the individual if they bond out. This bail reform concept, you've seen extreme circumstances in states like New York and California where the concept of bail is being used as a rotating door, and as people spin through that system, they never get held. So if you've got a revolving system that is simply taking people in and letting them out and not making them accountable, you will have multiple criminal activities on the outside, and the person keeps coming through the system. But you can't use bail as a punishment because they've not been convicted yet. So there's a fine line of that, and you have to leave the discretion in the hands of the magistrates who see the person. So, for example, what a magistrate should be doing is looking at what that person's connections to the community are. Do they have a family here? Do they have a job here? Is it likely that they will appear when they're asked to come to court? You set a bond appropriate. You don't set a bond that, like a $20,000 bond on a Class B misdemeanor DWI is inappropriate. But then you hear about these $1 million bonds on murder cases. Well, that's because they're looking at whether or not that person poses a threat to the community if they're released outside of the confinement facility. And they think that that would be a large enough margin that would confirm their presence and perhaps dissuade them from committing further crimes.
Okay. Any other thoughts you would like to share?
Well, I'm very happy to serve the public. I enjoy my job. As I said, we have to provide advice to multiple departments, and not everybody is going to be on the same sheet of music. But my job is not to write the law. My job is to interpret it and to apply the facts and circumstances that they present me with a problem and give them options. And that's my job. I'm happy to do it.
And so I assume that means you're going to continue to want to serve, maybe run
Well,
for
I like what
election.
I'm doing. Yeah. Yeah.
Good. Well, very good. Well, thank you so much for joining us today. This has been really, really good. And I just want to appreciate everybody for joining us. And thank you for watching Talking Texas Politics with Calvin. And God bless you. And God bless Texas.